But Mr. Alcock's lack of concern about Syria and about ever formulating an opinion about Syria not only concerns me about his mindset, but it has affected the whole agency. And I'll deal a little bit with some of the cross-examination of some of the people from there. In the in the Harkat case, Justice Dawson ultimately found that she was concerned about how Abu Zubaydah had been treated, but found another basis, and if you read the judgment, you'll see the basis, for excluding that one statement from him. She nonetheless found he associated with, Harkat associated with Abu Zubaydah, and she found the certificate to be reasonable. Eventually, we did a couple of bail applications for Mr. Harkat. One of them was successful finally, but in one of them, the first one, they called a CSIS witness who testified under the initials PG, and he was a senior analyst on Middle East issues. And I asked him questions about when you get information. Do you ask any questions about whether it came from torture? Does anybody ask any questions about whether it came from torture? The answers were all no, 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 and no. And it got so bad during his testimony, actually, the Justice Lemieux intervened in the testimony, started asking him some questions. What I did eventually in that case was I stood up before Mr. Justice Matheson, and before Mr. Justice Lemieux was doing the bail hearing, and I said about Mr. Matheson, who had been the counsel at the original reasonableness hearing, I said, it's very apparent Mr. Matheson hasn't talked to his clients at all, hasn't said anything to them about you should pay some attention to evidence obtained by torture. You shouldn't be allowing it in, and you should be trying to make sure whether or not the people who you're getting information from have been tortured. Well, Mr. Matheson got very upset with my comments about that, but I got to say that I think Mr. Matheson, like Mr. Alcock, they're both unethical, and they're improper in their behavior by not saying to CSIS, in Mr. Matheson's case to his clients, Mr. Alcock's case to his employees, you've got to pay attention to this. This is important. It isn't appropriate that you just turn a blind eye to torture. I then got to cross-examine another CSIS witness who testified under the names JP, and this was after the Arar inquiry had come out and said, not only was Mr. Arar tortured in Syria, but Mr. al-Malki, Mr. al-Mahdi, and Mr. Nuruddin are also tortured by Syrian military intelligence. And JP couldn't form the conclusion that Syria engaged in torture. And I asked him a bunch of questions because he used to do liaison work for CSIS, which meant dealing with other foreign agencies. And I said, well, if you concluded that Syrian military intelligence engaged in torture, could you have a liaison agreement with them? He said, no, we couldn't do that. It's really up to foreign affairs, but we couldn't do it. And I suggested to him that both he and Mr. Alcock never come to the conclusion that Syrian military intelligence engages in torture, so they can keep right on dealing with them, keep getting information from them. I want to talk about one more Canadian lawyer, and then I'm going to get to you and Bybee. Michael Pierce was the lead government counsel in the Yakabuchi inquiry, and one of the questions in the Yakabuchi inquiry was whether or not Canada had been involved in the mistreatment of those men. And the only position that the Canadian government would take at that inquiry was that the men had been mistreated. And Mr. Pierce, the lead counsel, stood up at the inquiry and said, we're prepared to concede, the government of Canada is prepared to concede they were mistreated. I wrote to him and I said, are you prepared to concede that they were tortured? I never got a reply to the letter. I raised it again with the inquiry. Mr. Pierce never responded to that. As a result of his non-response, all three men were obliged to testify, to relive their torture by testifying about it. I spent 3 days in a hotel room with Abdullah al-Malki while he testified in great detail about the torture that had been inflicted on him by the Syrian military intelligence. And the government counsel weren't there. It was a closed hearing, but they were given transcripts. They were given the opportunity to call other evidence. They were given the opportunity to cross-examine if they wanted, and they never took any opportunity to challenge the evidence. The Yakabuchi inquiry found all three men were tortured. I would suggest that Mr. Pierce, in his role as government counsel, again was unethical and improper in not conceding what was very obvious. Or if he wasn't going to concede it, at least engage in a litigation process, but not force the men to testify as to their torture. I have some parts in here about some amendments to the legislation after the Supreme Court of Canada struck it down. The only thing I want to touch on is there's one provision now in IRPA that prohibits the use of evidence obtained by torture, and that came about as a result of an amendment proposed by Ujjal Dosanjh during committee hearings, and he deserves very great credit because it has changed very much the focus of the security certificate regime and has, in one case, I'm just checking the time here. In one case, actually, during the Almery inquiry, or Almery reasonableness hearing, 2 portions of the 9/11 Commission report were excluded from the case because it appeared very much that they had been obtained, the information in them had been obtained from torture of Abu Zubaydah in waterboarding and torture of Khalid Sheikh Mohammed. And when the security certificates were reissued in 2008, all reference to any information from Abu Zubaydah had magically disappeared. I want to go back to Ewan Bybee. Not only did they write that horrible definition of what torture is, they went on to say in the memorandum that if anybody from the US government carried on activities that constituted torture, that went beyond their horrible definition of torture, if they did it on the orders of the president, they wouldn't be criminally responsible. So it just opened things up entirely. Most of the torture was done by the CIA. The FBI actually had the decency to decline to participate in those proceedings. But there have been attempts in the United States to deal with Ewan Bybee and figure out what you do with lawyers who write such horrible stuff. And I want to outline a little bit of what's happened with them. Both Ewan Bybee and a number of very senior lawyers in the US government. There's a investigative magistrate in Spain named Baltasar Garzón, and he's done a great deal of work in dealing with people involved in torture. He's the one who indicted Pinochet. He started doing an investigation in regard to 6 senior government lawyers from the United States. That investigation's on hold. I just got something on the internet today. Judge Garzón has been suspended from his duties. What he started doing was an investigation into the disappearance of more than 100,000 people during Spain's 1930s civil war and during the Franco regime. And it is alleged that he ignored a 1977 amnesty for all of those people. So he's no longer doing that investigation. There's a civil action going on in California. A guy named Jose Padilla, who's an American convicted of criminal conspiracy charges, and another guy are suing Jonathan Yu for saying, you wrote this memorandum, it resulted in us being tortured, you're civilly liable for it. You brought an application to dismiss the claim on the basis that he is insulated from a judicial inquiry into whether he violated the plaintiff's constitutional rights by his legal work in writing the Gonzalez memorandum. He lost that application. The case is now on appeal in the U.S. Court of Appeal in the Ninth Circuit. There were also complaints filed against Ewan Bybee with their respective bar associations. Those complaints are basically on hold. What happened was the bar association said, we want to wait and see what the Department of Justice does. There was a complaint about Bybee because he's now a judge to the Judicial Council that deals with him, and they said, it's not our responsibility. He did that when he's a lawyer.